Yes, please.
What can you say about we always say advisory opinions are non-binding. There were some issues with this advisory opinion. What can you say about the bindingness of this?
You can answer them both in the non-binding. He asked about the non-binding also. Please go ahead.
Well, that is correct, strictly speaking. An advisory opinion is not a judgment in a contentious case between two parties, which is legally binding on both parties. But an advisory opinion by the world's highest international judicial authority is an authoritative interpretation of the rules of law applicable in the particular situation that the court is considering. So what the court has done today is it has set out comprehensively all the rules of international humanitarian law and international human rights law that obligate Israel in its conduct in the occupied Palestinian territories. And because this is the world's highest judicial authority, those rules that the court articulated are the rules that apply to this situation. And all states, under the UN Charter and under customary international law, are obligated to comply with the rules of international law. So in that sense, the rules that the court articulated today as applicable to Israel are binding on Israel because they are rules of international law, and Israel is obligated, as all states are, to comply with international law.
Israel's first reaction was to say that it fully complies with international law. Would you agree on the basis of the ICJ's ruling of today?
Well, more importantly, I don't think the International Court of Justice would agree with that statement. I can't speak for the court, but the opinion that they read today said, one, Israel, as the occupying power, is obligated to ensure, a positive obligation, and is obligated not to interfere, a negative obligation, with the supply of the essentials of life, humanitarian assistance to the civilian population throughout the occupied Palestinian territory, but including the Gaza Strip. As I heard the opinion that the court read, the president read from the bench today, the court found that Israel has not complied with its obligation because sufficient supplies of the essentials of life, food, water, medicines, clothing, shelter, healthcare items, have not been adequately supplied, at least in terms of the civilian population of Gaza. So if the obligation is to assure that the civilian population is adequately supplied with the essentials of life, and the court has found that Israel has failed to assure that the civilian population has been supplied with these essentials, then clearly Israel is not in compliance with its obligations under international law. Moreover, the court found that there is a prohibition on the forced displacement of the civilian population. And we all know, the UN has found, and the court cited the UN reports, that there have been multiple forced displacements of hundreds of thousands of Palestinian civilians in the Gaza Strip. Those are just a couple of obvious examples from the court's opinion, which we only heard today, that bears writing. It bears reading the written text. We'll find more. The court also said that the starvation of the civilian population is, as a method of warfare, is illegal. It's also an international crime. But the court said it is illegal to deliberately starve the civilian population as a method of warfare. And at the same time, the court said that from March 2nd, 2025, until I believe it was the 17th of May, 2025, Israel deliberately and as a matter of policy prevented all food and other humanitarian supplies from entering the Gaza Strip. And thereafter, it severely restricted the supply of food and other essential supplies. So on the one hand, you have the court finding that starvation as a method of civilians, as a method of warfare, is illegal, it's prohibited. And on the other, the court found that Israel deliberately prevented food from reaching the civilian population in Gaza. I don't see how a reasonable person, certainly acting in good faith, could then say that Israel has complied with its international legal obligations. Plainly, it has not.
Anyone?
Do you think that you will, do you know how you will use this decision, like you did, for example, with the occupation opinion, you went before the...
Very important question, I think. The decision could be used first with those reluctant states who question the intentions of UNRWA. So those intentions are no more questionable in the eyes of law, right? Whether the UN is allowed or not allowed, whether security considerations are something that should be considered or not. All of these are no more valid for in the eyes of the law, and no more valid even for states to make excuse out of. We knew that they were not valid in the first place, but sometimes it needs a court of law to make these determinations, as the case with genocide. How much reluctance we are still facing from states to make the determination that what's happening in Gaza is a genocide, in spite of the fact that all major relevant and important international bodies and independent bodies and jurists in this field have made this determination, including the last report of the Commission of Inquiry of the United Nations. Yet you still see this reluctance. This reluctance can no more exist in the eyes of law. The court has drawn a clear line between what's allowed and what's not allowed. A denial of humanitarian aid under any pretext is not allowed. You cannot make any excuse not to allow humanitarian aid. Certainly, starvation continues to be prohibited as it was to start with, and it goes on from there. The court will put an end to any stupid argument that would argue to the contrary, which we knew beforehand that it is. And some were even justifying it in the media or coming out states to make excuses for Israel, or even claim that what they have created in the sense of a replacement to the United Nations is acceptable. The court said that is not acceptable and that does not suffice. Therefore, you need to allow the United Nations, international organizations, and third states. So it is very important in the sense of what our people were subjected to starvation and denial of basic needs for their survival.
I have a question, actually. The wording of the advisory opinion itself does not specifically say Israel has violated these provisions of international law. It seems like the court is just outlining what international law says and what should be done without actually accusing Israel or ruling that Israel has violated any of its provisions. Why is that so, and what do you make of it as Palestine's legal team?
In answer to that question, my sense is that the reason why the court might not have done this is speculation on my part, is because the violations by the occupying power unlawfully present in the territory are so replete, so overwhelming, so large and broad that it would be impossible in a short hearing of some 2 hours to catalog them all. What we have is very clear determinations made by the court of fact that the population is inadequately supplied, including through the actions of the illegal occupying power. Also, we have clear indications from the court, affirmations, that the occupying power has obligations in such circumstances to so supply the population that is inadequately supplied by it. One of the things that strikes me with the opinion is the findings made by the court in respect of UNRWA. Now, much has been made by the State of Israel alleging that UNRWA, the backbone of the United Nations humanitarian presence in the occupied Palestinian territory, is somehow compromised with its neutrality or its integrity. The court was unequivocal in asserting that despite these allegations by Israel, Israel has not made them out, and therefore Israel has an obligation to work within the United Nations structure and within UN law to deal with any concerns it may have. But until such time as it does, it has to facilitate access of UNRWA, the largest United Nations organization on the ground in the occupied Palestinian territory, including in the Gaza Strip, unconditionally. For me, that's very clear, especially in the circumstances where the people on the ground are suffering, don't have access to food, fuel, shelter, water, and so on. UNRWA is the lifeblood of UN humanitarian aid and assistance, and the court was very clear in that regard.
Anyone else? Please go ahead.
How this ruling will help rulings to come in regards of South African application of the court?
I'll be brief there because the court has said it clearly that they will avoid any attachment and they will avoid anything that relates to that other case because it's a standing case. The merits of this case is based on IHRL, meaning international humanitarian law, international human rights law, and the privileges and immunities and other principles under those. That is a different path and a different route. But in my opinion, the issue of starvation itself is a very damaging aspect. For us, also the reiteration of denial of humanitarian aid and not allowing it to come in, denying it for a period of time which the court recognized between March and May. And it goes on. Certain aspects will be beneficial, but I don't think they are completely separate cases according to the court. Anything to add in that sense? Yeah. Anyone else? Thank you very much for your time and for your patience and for being here with us today. Good day to you.